Well, I think it's safe to say that the right of privacy as we think about it in American law wouldn't exist without Louis Brandeis and Samuel Warren's article in the Harvard Law Review in 1890, which is one of the things that we will be talking about. And I think it's safe to say that our whole notion of life in America wouldn't be the same without that sense of privacy. The type of privacy that Warren and Brandeis introduced in 1890 really had to do with prying newspapers and journalists and photographers. So it was a tort notion of privacy, not the constitutional notion of privacy we think of so often. But by the time Louis Brandeis was appointed to the United States Supreme Court and had an opportunity to speak about issues relating to privacy, he took that opportunity in the case of Olmstead to dissent and to suggest that there was a Fourth Amendment right of privacy. So he's now pushing his notion of privacy further into the constitutional realm that was potent enough to require the government to get a warrant before using, at the time, new technology, which was eavesdropping, electronic surveillance. And then later, even after Justice Brandeis had left the court and passed away, this notion of privacy again was pushed forward, always with new technology being the impetus. When we get into the 1960s and 70s with the cases of Griswold v. Connecticut and Roe v. Wade, introducing a true constitutional notion of privacy that I call fundamental decision privacy, saying that there were certain decisions in one's life that were broad enough to encompass a right to choose whether to use contraceptives, whether to have abortion, again, prompted by changes at this point in medical science and technology. So all of this leads us to today, when we have many assaults on the notion of privacy in the terms of the government warrantless wiretaps that became public during the Bush administration, in terms of all of the new technology dealing with cell phones and Facebook and things being pictures being put up instantaneously of people that they may not want to be made public. All of this implicates Justice Brandeis's original notion of privacy.
Okay. Before I let you go, maybe one other question. The current Supreme Court, could you give me just a little bit of thought on how Justice Brandeis's influence on privacy rights has fared well recently?
Well, I would say that the current, it's so well ingrained, this notion of privacy, in our American jurisprudence. I don't think you can necessarily separate out liberal, conservative, and say one group is for it and one is against it. I don't think that's the case at all. You have to, again, look at each type of privacy. For instance, Fourth Amendment search and seizure privacy, there have been cases where both conservative and liberal, in quote, justices have come together to find that there have been invasions of privacy. I think the diciest category would be the fundamental decision privacy, because some justices would believe that there is no such thing as this due process, substantive due process right that is broad enough to encompass privacy under the 14th Amendment. But other than that category, I would say that, again, the notion of privacy is uniquely American and deeply entrenched at this point, and I don't see any segment of the court just abandoning it in any wide-scale sense.